Good evening and welcome. It is now 6 o'clock. I'm handing over to Dr. Koza. Dr. Koza, over to you.
Good evening, everyone. Welcome to our live webinar. So this webinar, it's our policy. Sorry, let me switch on my video. Okay, so this webinar is our virtual policy dialogue. So the aim is to just help us come up with our contribution to the labor law amendment bill. So the way that our country works is that we've got parliament. So parliament, that is where the laws are made. But before they are signed off or they are adopted, the public is given a chance to voice out their opinions and raise any concerns that they may have with such laws. So currently, the one that is being amended, it is the labor law, our labor laws. So we've invited a couple of experts to give us good insights on some of our labor laws that affect doctors specifically. So some of the topics that will be covered, it will be locums and the expanded definition of an employee, parental leave reform, expansion of CCMA jurisdiction, and remuneration-related amendments and collective bargaining and essential services. So each speaker will be given 12 minutes to present, and then there will be 7 minutes of question and answer. And then before each speaker comes in, I will give a brief intro for the speaker. So yeah, that's basically what's going to be going on today. So we'll go straight to the first speaker. The topic will be expanded definition of employee, and then the impact on locums. It's gonna be Letitia Volkswegel, a labor law expert from Summers Legal Department.
Thank you, Dr. Koza. May I take over?
Yes.
Thank you, Doctor. I just want to share my presentation. There we go. Okay, so basically what I'm going to talk about is the expanded definition of employee and the impact that has on locums. And the impact is not only on locums. As we go through the presentation, it will become clear that there may also be an effect on those doctors employing locums. So first of all, there always used to be this concept of independent contractor, and locums classified as independent contractors for most part. And what the bill intends to do is to basically change that to dependent contractor. Now, we have to ask the question, is this a shift in protection for locums? So the new dependent contractor concept comes from the BCA bill, Section 50A, as well as the Labour Relations Act bill, Schedule 11. And both of these bills, the amendment that is proposed is to include that any person who performs work for another is not conducting an independent business is presumed to be an employee for dispute resolution and collective bargaining purposes. Now, this is a big expansion from what it used to be, as as independent contractors were excluded from this, and they might now enjoy inclusion. So basically what happens is in such a relationship between two doctors, there's always a presumption that the employee or the locum, or whether this will be in effect with the amendments. It's not currently the case. So basically what is in existence is a 3-part rebuttal test. And the test basically asks 3 questions, and the employer is responsible for rebutting all of these factors. So the questions that will be asked is whether the employee is subject to the employer's control and direction, and furthermore, whether the employee is part of the employer's organization, and whether the employee does not perform work for clients on behalf of the employer under the employer's terms. So if any one of these 3 fails, so all of them need to be answered, and if any one of them fail, then the person is regarded as an employee. So what is the impact on locums? Currently, under the current law, locums are independent contractors. They don't pay UIF, they don't qualify for leave, and they have no unfair dismissal protection. So under the proposed bills, many locums could be reclassified as employees. And that will be the case if they are rostered by the hospital or the practice, if they use the hospital or practice equipment, if they follow hospital or practice protocols. In other words, there's a form of control by the employer or the hospital, and whether they treat the hospital or the practice as patients on behalf of the employer. Now, you will see from many locum doctors will recognize that this is currently what is happening in their instances. They are rostered by the practice hospital. All of these factors are applicable, but currently they do not enjoy the protection by the labor laws, and they are not recognized as employees. So what will ultimately happen is, if they are regarded as employees, one of the biggest things that is a positive change in my view for locum doctors is that they will enjoy unfair dismissal protection. This basically means that they will be able to refer a dismissal which they regard as unfair to the CCMA, and the CCMA will have jurisdiction to hear the matter and to adjudicate the matter because they are regarded as employees. So you will see at the bottom of this page, we highlighted key risk, and the key risk is for employers, because basically what a locum doctor can currently do when they are, I don't want to use the word dismissed because dismissal is not relevant currently in this sense, but let's say the locum doctor is let go. Let's call it let go. So the locum doctor is let go, and the only way in which this locum doctor can challenge this step by the employer is to actually challenge it on the basis of breach of contract. And that would mean they will have to approach a civil court to hear the matter. So this basically means for the employer that the locum doctors would have easier access to a tribunal that can consider whether or not there was an unfair dismissal. Okay, so we move on. The other thing that is very interesting about the amendment of the bill, and this is specifically in the Basic Conditions of Employment Act, Section 9B, this applies to locums and on-call workers. So the employer is obliged to provide a written agreement with key employment terms. And the purpose of this envisioned section is basically to protect those that work on an on-call basis. And what this written agreement must specify is basically the maximum hours per period, the availability period, reasonable notice to report, and reasonable notice of cancellation. In other words, what we anticipate is that you cannot be called 1 hour before your shift by the hospital or the employer, and they share with you that you are no longer needed. What we further anticipate will happen is that if there is a cancellation without the required notice, the employer must still pay the employee for the cancelled hours. One of the other key factors is that the locum doctors will, under this provision, also be eligible for sick leave. and it will be worked out on a 1 day per 26 days work. This is a specific formula for on-call employees. So one of the things that we need to point out is that there's and this is something that exists in current labor laws as well. We call it the earnings threshold. So to explain it is basically people earning above the threshold. The threshold is currently in the region of about 260,000 Rand per annum. So you can see it's not very high. And it basically means that anybody earning above the threshold does not enjoy certain benefits under the labor law or certain protection under the labor laws. So what we envisage is going to happen in this case, it might not happen, but there will be a possible earnings threshold exclusion for high earning employees. Now, what is proposed at this stage is that the exclusion will be relevant to anybody earning over and above 1.8 million Rand per annum. So as you can see at the bottom there, I made a note that this may exclude most specialist doctors. So let's look at the consequences of the reclassification if the presumption is applied. So if a locum doctor is reclassified as an employee, suddenly there will be UIF contributions, PAYE will be deducted by the employer, they will qualify for annual and sick leave, they will enjoy the unfair dismissal protection that we already spoke about, they will have collective bargaining rights. And then if you look at the situation, if they remain independent contractors and they are not regarded as employees, the status quo will basically remain. In other words, there will be no UIF. They are themselves responsible for their tax. There will be no statutory leave. There will be no dismissal claim, and they have no access to a union. So the question that we need to ask is whether this is desirable or problematic for locums. I would say that it provides locums with more security, and I want to come back to the unfair dismissal example that I made. I think this is one of the key factors where locum doctors will enjoy protection. But also this means that there will be less flexibility for the locum doctor, and there's going to be a higher administrative burden for the hospitals or the practice. So this is from the point of view of the employer. So some of our members are also employing doctors and not only locums, so they might have this higher administrative burden and then also face repercussions if there is an end in the relationship between the locum and the employer due to the fact that unfair dismissal protection is applicable. So I've listed a couple of questions that are key discussion questions that we should discuss and think about in order to formulate an input to the proposed amendments. So question 1 is, would a locum rostered by a hospital or practice using its equipment and treating its patients satisfy the 3-part rebuttal test? And what contract changes would help in this regard? Question 2, if reclassified as employees, what consequences would follow? As I've indicated above, would it be desirable or would it be problematic for locums? Question number 3, does the possible earnings threshold exclusion adequately protect most SAMA members, or does uncertainty itself create risk? Question number 4, how would SAMA address the on-call cancellation pay provision? This is what I referred to above, where you are not given sufficient notice that your call is being cancelled. Is it workable in the health sector where shifts are booked spontaneously? And lastly, question number 5, what steps should members take now, such as contract review or practice restructuring before the enactment of the new laws? That is the end of my presentation, and I'm looking forward to any questions that you might have in this regard. Thank you.
Thank you, Letitia, for the insightful presentation. You did well in terms of time. I'll ask everyone to please post your questions in the chat, then I'll read them out to Letitia. While you're still posting the While you're still posting your questions, I'll take the time to introduce myself. I was in a bit of a rush. I think we got ourselves a bit of time. So I'm Dr. Courage Koza. I'm a public health medicine specialist. I'm part of the Health Policy Law and Ethics Committee of SAMA, and I'm the facilitator of the day. So you can post your chat, your questions on the chat, and then I will read them out. So this is a very interesting topic because it comes at a very interesting time for our profession. We know that the Department of Health has appointed a task team to review certain labor laws that affect us as doctors. So as SAMA, it's important for us to also take a process to do something similar so that we can input. Okay. So it's very important for us to contribute in any way which we can. Let me see if there are any questions on the chat.
Dr. Koza, the questions are just in the Q&A section. Questions would be under Q&A at the bottom.
Thank you. Where is your... Oh, there. Yes, on the Q&A section. Thank you. Okay, the first question is, with these changes, what are the responsibilities of the locum agencies, i.e. a facility contract and agency, to provide medical staff on ad hoc basis? Okay, over to you, Letitia.
Thank you, Doctor. This is an interesting question. Sorry, I just want to switch on my video so you can see me. There we go. So this is a very interesting question. So one needs to now expand this to the fact that some locum agencies act as the party between the employer and the employee. And it will depend basically on whether this person, the employee, qualifies in terms of the rebuttal that we spoke about, those three questions, whether that person will be regarded as an employee or independent contractor. So in my view, what the legislator tried to do is to provide extended protection to people that previously did not enjoy the protection of the labor laws due to the fact that there might be a middleman in the equation. And I think if the rebuttal can be proven, then basically that middleman will fall away and that employer, that doctor or that hospital will be regarded as an employer, and that the locum will be eligible for the protection under the labor laws.
Thank you for the answer. The next question is, will this be applicable to surgical assistants as well?
Yes, it will definitely be applicable to surgical assistants as well. And once again, not to hammer on it too much, but remember what I said about the rebuttal. There's going to be a test in terms of how you establish whether someone qualifies as being an employee or not. So that will also be the case in this instance.
Thank you. Next question is, are they an employee of the agency or of the facility?
That is interesting. So basically what happened in the past is that because of the earnings threshold, remember I mentioned that there is currently an earnings threshold in place, and it's not the one that we discussed in the presentation of 1.8 million rand that we are envisaging might be implemented. It is basically the 260,000 rand per annum threshold. So what happened currently, or what is currently the situation, is that if someone is earning below the threshold, then the employer can be held responsible as the employer. Okay, let me put it this way. The agency and the employer or the employing doctor will then be regarded as employers for the purpose of dispute resolution processes. So it will be interesting to see whether after the amendments are made, whether this will still be the case and whether the earnings threshold will be pushed up to such a point that it will actually include our doctors and provide them with the necessary protection. So as the situation now stands, basically, if we forget about the 1.8 million earnings threshold and we consider the threshold that is currently in place, it will basically mean that and anybody earning above that will find himself being an employee of the agency and not the facility.
Thank you for the response. The next one is, can a locum still be appointed as a medical consultant or general practitioner with labor law benefits, but own tax responsibility? ITO basic salary income with percentage commission earned will be below 1.8 million per year.
That is also an interesting question. So basically, the short answer is no. And I just want to expand on that. So if you are employed, it basically means, and only employees can benefit from labor law provisions. So if you are going to be regarded as an employee, the employer will be obliged legally to ensure that tax is deducted. So you will not be in a position where you can sort out your own tax. You will be, I don't want to use the word forced, but yes, it will basically be forced upon you to pay PAYE, or let me put it this way, it's going to be deducted from your income even before you receive your income.
Okay, thank you for the questions. I'm just wondering whether this will now discourage like hospitals or other doctors from hiring locums. What do you think in that regard? Do you think it's something that will be more beneficial, or it's something that will actually negatively impact the profession in terms of people no longer hiring locums?
Dr. Koza, that is a very relevant question. So I think there is remember we said we need to look at the benefit and the risk, and the one does not come without the other. So unfortunately, in my view, I think it will be better for locums because of the protection that they will enjoy under the labor laws. But it is not going to be beneficial to the doctor or the practice or the hospital that employs the locum doctor, because as they are now enjoying protection under the labor laws, it will also mean that they've got access to labor law forums or to forums where they can refer their matters should there be an unfair labor practice or should there be an unfair dismissal that they wish to challenge. As I've mentioned in my presentation previously, the only way in which you could fight the cancellation of your contract as a locum doctor would be in a civil court, taking civil action against the employer. But with the amendments, it basically means that you can have a cost-free option of approaching the CCMA, and you do not have to incur the cost to challenge it by approaching a civil court. So yes, in short, for the employer or the practice or the hospital, it might be problematic, but on the other hand, for the locum doctor, it might mean that they will enjoy the protection under the labor laws, and that will make their life easier.
Okay, thank you. There's another question from Dr. Berry. It says, in regards to surgical assistants, will the surgeon then have to employ the assistant as permanent if they only help with one list a week, or only weekends or after hours?
I see. Okay. So basically, it's not as easy to say whether the person will be appointed on a permanent basis. Currently, the Basic Conditions of Employment Act says that if anybody works for you for more than 24 hours per, sure, I stand to be corrected, 24 hours per month, then basically they are regarded as an employee and they should be then enjoying the benefits as provided for under the labor laws. I stand to be corrected, and maybe Mr. Wellman can just correct me on this point, whether it's 24 hours per month or 24 hours per week. I do suspect it's 24 hours per month. I know it is quite a low number. And to answer the question of Dr. Barry, it will basically mean that if you have this person work weekends and after hours in your practice, and they work more than 24 hours per month, it would basically mean that they will be employed on a permanent basis.
Okay, thank you. Next question is from Dr. Muller. But it's more of a comment. It says, it sounds to me as though state and NHI will be more at risk. Any response to that?
I see what Dr. Miller means with this, and I do understand that that can be his point of view, and yes, absolutely. It might very well be that the state and the NHI would be more at risk. I agree with that statement.
Okay, thank you. We've got a response in the chat about the 24 hours. It's from James Wellman. It says that it is 24 hours per month. Yeah, so that is the cutoff.
Sure. I thought so because I know it's quite low. And yes, absolutely. Thanks, Mr. Wellman, for clarifying that.
Okay, thank you. Any other questions for Letitia? Last question before we go to the next speaker. What prompted the change of this definition from the government? Was there a specific case that resulted in this, or is it just amongst the issues that were just added to the list of labor laws that need to be revised? Thanks.
There was no specific case that I can refer to that brought about the proposed amendments. It is basically, in my view, basically the rationale behind it is to provide more protection to people that might find themselves vulnerable in certain situations.
Okay. Another conundrum Dr. Berry's throwing. An assistant can help more like multiple surgeons. So you'll be an assistant, you'll be called by this surgeon to assist, and then tomorrow you're called by the other surgeon. Next week you're booked by another surgeon. So what happens in that case?
That is an excellent question because we know that currently locums as independent contractors are allowed to provide their services to more than one employer. And there is a bit of unclarity as to what will happen if locums then commit themselves to one employer. I would suggest that it would basically depend on contractual agreement. So basically between the employer and employee, they will need to clarify the situation as to whether they will allow the person to provide services to someone else. In my view, it would be really unreasonable because some locum doctors, as was previously mentioned, what if you only use someone over a weekend to perform a couple of hours or they only do after hour work? It would basically mean that there will be an injustice if you then prevent this person to provide services to someone else as well. So interesting question, and it would be interesting to see how the amendments are going to be developed in order to cater for that situation.
Okay, thank you. Next question, which will be our last one, is from Dr. Weinand Goosen. It says, in the past, a locum was employed on a temporary trial basis for 3 to 6 months before a final decision of permanent employment was applicable. Is that still correct?
Well, if the amendments are enacted and accepted as is, and as we've seen now in the presentation, it would basically mean that the provisions of the Basic Conditions of Employment Act dealing with the probation period will be applicable to locum doctors as well. So yes, the short answer is yes, probation periods will still be applicable.
Okay, thank you. That was our last question, and another round of applause for Letitia. Thank you for the insightful presentation. We'll go to our next topic, which is parental leave overhaul. It will be presented by Mpiwa Tsanga, who is a human rights lawyer and policy advocate for Sonke Gender Justice and one of the architects of the original versions of the parental leave amendment. I'm sure we've heard it was trending when the judgment was made that men can now take what was called maternity leave, and it was trending with the social media and the people saying lobola, women must lobola and all of that, but that was more on a lighter note. So we've got the expert with us today to tell us more about the changes. Over to you.
Good evening. Thank you. I hope I am audible. Can you hear me clearly?
Yes, we can hear you.
Okay. So as has already been said, I am with Sonke Gender Justice, and Sonke Gender Justice, we were part of the litigants in this case, which we call the parental leave case. I'm trying to see if my presentation. Oh no, okay. Okay, can you see my presentation now?
Coming on. Just
Yes.
remember to full screen it as well. Yes, thank you.
Okay. So just as a case background, that this case was taken to court to challenge the Basic Conditions of Employment Act and UIF Act, particularly the sections that speak to maternal leave and the applicants there were the Van Veeks, and then we joined in as Sonke Gender Justice. And the issue was the discrimination that was in the act as it granted shorter leave for fathers and adoptive and commissioning parents. So our argument was that we need a more gender equal parental leave regime for all families. So, and the stated acts, we highlighted that the law was unfairly discriminating by gender, by family structure, and by adopted child's age, which violates sections 9 of the sections 9 and 10 of the Constitution. And so we were advocating for full equality in caregiving and also challenging the patriarchal norms that are associated with caregiving and advocating for more shared parenting. So these are the sections that we challenged as unconstitutional. It was Section 25, Section 25A, Section 25B, and Section 25C of the BCEA, and also Sections 24, 26A, 27, and 29A of the UIF sections. So the discriminations were that we're saying mothers get 4 months and fathers were getting under the current law, mothers get 4 months, fathers get 10 days, and then adoptive or commissioning parents get 10 weeks. And there's an age limit in terms of where adopting parents are concerned. It's only under 2 years. So meaning children from 2 years and above, this does not apply. So we then, I think I'll just move on from there to say that first, So when we went to court with the Van Wyks, our argument was that each parent should be given their 4 months leave, and then they should be able to, whether they take it or not becomes their choice, but the 4 months should be availed to each parent. And the Van Wyks then were arguing that the leave should be shared. They were advocating for 4 months leave to be shared amongst both parents. They are to decide how this is to be shared. So now the judgment that was given in the High Court, which was subsequently confirmed in the Constitutional Court, was to say the stated provisions, these provisions have been declared unconstitutional on the basis of the reasons that I have shared. And now there's been a reading in to say that parental leave is going to be 4 months plus 10 days, which is to be shared. So parents choose how they, where parents are co-parenting or married, they choose how to split it. One employed parent, it's they get full leave, and then also birthing mothers must still take their 6 weeks post-birth recovery leave. So what has happened is the declaration that the provisions were unconstitutional was suspended for 3 years. This is to enable or to give Parliament room to then go and legislate to address this anomaly or to address the discrimination. However, the Constitutional Court did not leave a gap. So in those 3 years, what is going to happen is this is how the parental regime now looks like until this bill, since this bill that is currently under consideration is passed through with whatever provisions that it's going to make. So this is now how the law, when it comes to parental leave, should look like. So what the bill is doing, some of the key proposals is the bill is now seeking to make the shared parental leave system permanent. So it's seeking to then say parents have 4 months 10 days in which they can split that according to how they deem fit or how they agree. And also where the parent is a single parent, then they take the full leave, or where one parent is employed, then they also take the full leave. And then it seeks to extend adoption leave to children up to 6 years old. Currently, as I highlighted, it's up to 2 years. So the amendment seeks to now extend adoption adoption leave to 6 years. And also it wants to then replace maternity UIF benefits with shared parental benefits. So essentially, as we know currently, maternal leave is still, it's unpaid leave. Then you claim from UIF, and for most companies, save for those companies that are progressive enough and they've decided to give paid maternal leave. So now the proposal in this bill is to then say that the UIF benefits are then shared as well between the two parents. So where there was where there was going to be a claim for UIF benefits for maternal leave, then those are split into two, and then the two parents share that claim. And then and also, yeah, so it also allows for, it's proposing flexible splitting or concurrent or staggered leave. So essentially parents have to agree on how they are sharing the leave and then make those submissions to their employers, and that's how the leave is going to be addressed. So however, what the gaps are in the bill right now is that one of the gaps is the over-reliance on unpaid leave. So it's still making the leave unpaid, and also reverting to claiming from UIF, but also it's unclear. There's lack of a clear UIF benefit structure, because it's just saying that following the same path of the leave being shared, it means that the UIF will also be split. Each parent will claim 17 point something weeks of those benefits. And also there is and there's no strong father specific entitlement in terms of that leave. And also there is still weak integration with public health system. So those are some of the gaps that are still there in what is being proposed in the current bill. And I think still parental leave is being treated as a labor issue, but also it's a determinant of maternal health well-being also, which would fall within the mandate of your organization. And so there would be need for your organization to make contributions in terms of particularly around the impact on maternal and neonatal health. Also is, for instance, products to recovery leave for birthing mother shared between two parents, and birthing mothers also still have to have their 6 weeks recovery. It has sort of weakened what was currently available for birthing mother in terms of maternal leave. So those are some of the issues with the bill, that while it's proposing to align with the Constitutional Court, there are still those gaps in terms of how then do we balance the needs of a birthing mother, their recovery needs, their neonatal needs, the childcare needs, but also ensure that there is a balance in terms of the role that both parents play in terms of their parenting roles and responsibilities, which is what had really taken us to court in the very first place, to say there needs to be a balance in that responsibility. Also, the challenge with it's the approach is to increase the leave for adoptive parents to only 6 years old, but then that's to assume that what about the needs of children who are adopted who are above the age of 6 and still also have the needs and the same, they also need to be cared for, they need to assimilate, they need to adjust and assimilate into their new families, and yet there does not seem to be that consideration of their needs, of the time that parents need to then go through that period, that process of adjustment with children who are above the age of 6. And also there is the issue, like I said, of UIF, which would also be a discouraging or a deterrent for some parents, particularly fathers, who would want to also take parental leave. But if this is not clarified in terms of how this UIF claim is being made, how the payments are being made, and so forth, it also leaves that gap, which becomes a discouraging a deterrent in terms of taking up the leave. So I think I will pose it here to say this is what the law currently, this is what the Constitutional Court case has, that's how it has impacted the law, and these are the proposals that the bill is making, which are really to try and align with the Constitutional Court case, but also leaving these gaps that still need to be addressed. So I will pause here.
Thank you, Ms. Tsanga, for the informative presentation. We're now gonna go to questions and comments. We can give a round of applause for the presentation. You can type your questions on the Q&A. Just to note that you don't have to wait till the end to type the questions so that we can see them immediately. You can type them as the speaker is speaking, but I can start with my question. I just wanted to ask, in terms of your court case, what actually triggered it specifically? Was there a specific case in particular that triggered your organization to go to court? And can you tell us a little bit more about your organization specifically?
Okay, so yes, there was a case. The first applicants are called the Van Veeks. This was a couple that lives in Polokwane that had a child. The husband was working in the corporate sector, and the wife was a small business owner. So after a while, after the wife had given birth, they now wanted to address the issue of the wife needed to go back to take care of her business because yeah, she was worried that she's a small business owner. She needed to be more hands-on and needed to go back. So when they engaged with the husband was then saying he is willing to then also take leave to take care of the baby while the wife went back to take care of business. But that's when they discovered that there is a gap in the law in that the father could not claim for he could not claim for paternity leave at the time. He wanted paternity leave and was told that beyond the 10 days there is no further leave that he could get, and in spite of the wife being willing to go back to her work before the 4 months period. So then that's when they discovered that legislatively there's only 4 months maternal leave, but there was no leave for fathers. So that's what prompted this couple to approach the court to say there is a discrimination in that fathers are not granted, or both parents are not granted the same amount of leave for them to be able to take care of their newborn baby. So how we then came on board as Sonke Gender Justice. As Sonke Gender Justice, we're a human rights organization, and one of our interests is addressing issues such as the burden of care work. And one of the things that we've been saying was that women always bear the brunt of the burden of care work, because and we are trying to promote more equitable sharing of responsibilities. We are also an organization that engages men and boys to address gender inequality. And one of our ways is that we've been wanting to engage men to be more involved in parenting their children, because research has shown the benefits where both parents are involved in early child care, the benefits that it has for both the child and the parents. So it is from this angle that we came onto this case. And as I said, our interest really was, can both parents, or rather, can all parents be given equal parental leave? Each parent be given their 4 months. A mother will go for 4 months. A father will go for 4 months, so that both parents are able to be involved in the parenting of the and nurturing of their children from the beginning. Because what then we're arguing is that the burden is left with the birthing mother, or it's left with the mother to then take care and nurture the small baby, and that also comes with its form of exhaustion and mental health issues, postnatal depression and all. Some mothers struggle with that, and they are the ones who are also the main carers of their babies. The other partner has to go back to work, and it doesn't help much in terms in their mental health, and they are still also trying to recover. So it's from that angle that we then decided to also go to court for this case.
Okay. Thank you. Next question is from Tabi Soyende. It says, I would like to know if the proposed bill applies to married couples only or also unmarried couples. Of course, one need to consider fathers that would be regarded as absent.
Okay. So the bill doesn't apply to married couples only, it applies to parents. It's about parental leave. So even if parents are not staying together or are not married, but they are co-parenting, if both parents are present, so it applies to both of them to have to be able to share this leave and balance this leave. And where there is a parent, it's a single parent, that's only when the leave will not be shared.
Thank you. Next question, it's about breast feedings from Ignatius Smith, that we should think of the breastfeeding mother as the father will the father be breastfeeding now that he will also be getting the parental leave?
Okay. Yes, I mean, the father will not be breastfeeding, but there are certainly ways in which they can support the mother in terms of taking care of the baby while the baby, where possible, a mother can express, and when they have expressed, the father can also assist in feeding the child. Where the child is also being bottle fed, the father can also assist in feeding the child from, using the bottle feeding them. And also it just goes beyond just the feeding to the whole taking care of the baby, ensuring that they've had the milk, their diaper is changed, they are soothed, they sleep. We are looking at the way of saying holistically, the care that a child needs should not only be the responsibility of one parent, especially even those formative months or those early stages. It shouldn't only be the burden of mothers, especially because we know that it also impacts on their well-being, on their mental health, and also on their ability to be able to go back to work, to pick up on their careers and so forth. So there should be a balance in how this parental leave is distributed. Obviously, what I will say is there is the issue of the 6 weeks, to say what does it mean if the leave is being shared 4 months 10 days, but a birthing mother needs that 6 weeks to recover. How much time is then really left to share between the two parents in terms of the parental responsibility?
Okay, thank you. So that was the time we have for questions. I think any other questions, they can be posed on the chat and then they can be answered there on the Q&A part. We're gonna take a short comfort break. We'll be back at 7 o'clock. You can go to the bathroom or grab coffee or whatever, and also consider what you're gonna do with your new parental leave as a man. Thank you. See you in a few minutes. Welcome back, everyone. Hope you had a good comfort break. We're gonna go back to our program. Our next topic. Our next topic is gonna be the expansion of CCMA scope. Let me just switch on my camera there. There it is. Okay, and our speaker, it's a very learned colleague. Today we've got lots of lawyers, very learned colleagues. What happened? Someone pressed something that changed my screen. Okay, I'm back. So we've got Mr. Lutando Moyake. I'll just tell you a little bit about him. So he is a labor law consultant for Mjesha Dema Attorneys Inc. with vast experience in the field of law. Noteworthy experience ranges inter alia from providing labor law advice to clients relating to the drafting of employment contracts aligned to the labor laws, drafting of employee focused company policies, drafting of legal opinions, industrial relations training, chairperson's training, briefing external counsel where necessary, and engaging with unions representing employers at CCMA proceedings, advising inclusive of facility misconduct, incapacity proceedings, and restructures and transfers in compliance with the Labor Relations Act. He's currently an admitted attorney of the High Court and has completed the Advocates Training Program through the National Bar Council. Noteworthy experience ranges inter alia from providing labor law advice to clients relating to the drafting of employment contracts aligned to the labor laws, drafting of employee-focused company policies, drafting of legal opinions, industrial relations training, and chairperson's training. So he's currently employed as a part-time CCMA operational commissioner. He has trained extensively within corporate sector on the Employment Equity Act, in particular workplace harassment and bullying. His background stems from various entities, namely ETV or ENCA as an ER manager, Amalgamated Beverages Industry, that's AB InBev, that's the ones that make the beer, as an ER specialist, and Discovery Limited as an industrial relations specialist. He's a chairperson or panelist at the NHBRC, panelist at Dokiso Dispute Resolution, and LabourNet Pty Ltd and Direct Access Financial Service. He has 12 years experience in the field. So he is a very learned colleague indeed. Over to you, Advocate Moyake.
Yeah, okay. Thanks everyone. I think I just lost about 4 minutes of my presentation, but let me just bring up my screen. Can you hear me properly? Can you hear me properly?
We can hear you, Advocate. Thank you.
Okay, thank you. Okay, so thank you so much for the opportunity. Can you see my screen at least? What I just presented here.
We can see it. Thank you.
Okay, so obviously, I mean, we're speaking about mainly the expansion of the scope in terms of the Employment Equity Act. And obviously, any law, when it comes to labor law, is generally tied into some other law, like the Basic Conditions of Employment Act, the Labor Relations Act, and obviously the Employment Equity Act. So how these laws tie in is that Employment Equity Act is about discrimination, and there are all sorts of types of discrimination. It could be sexual harassment. It could be based on your skin color. It could be your pregnancy. It could be your political beliefs, your religious beliefs in that regard, or it could be for arbitrary grounds in that. So why these three tie in is that certain rights are afforded to certain individuals or forums like the CCMA and the Labor Court. So depending on how much you earn, I mean, currently now, there's a threshold that says if you earn below a certain amount, which is about 22,466, it just came up, I think, now at the end of March or April. And as it currently stands, but obviously with the proposed amendments, is that if you earn below that amount, then if you have an employment equity dispute, you can either go to labor court or you can go to the CCMA, which is a free service. Labor court means lawyers, means money, means advocates. So it was intended to protect those individuals that obviously earn below the threshold. Now, when these laws change, the BCA comes into effect because there has to be an amendment to say if you now earn below above a certain amount, you also have an entitlement to go to take your dispute to the CCMA, as opposed to obviously if you earn above, you can go to the High Court. So this is where ideally these laws sort of tie in, but I'll expand on it just now. So three distinct expansions of the CCMA's jurisdiction. So basically more powers are being given to the CCMA now to deal with employment equity disputes, and obviously for at all ranges in that regard. So it says that basically in the past, or as it stands now before the changes, that CCMA had sort of the exclusive jurisdiction to deal with sexual harassment cases, as opposed to having to go to labor court because of the sensitive nature, the cost implications, the victims obviously that suffer in the process of having to wait between 3 to 5 years for a court date. So that's why CCMA was granted this jurisdiction, because obviously it's a quick and expeditious and costless, less costly process in that regard. So now as things stand, the changes have obviously indicated that or any harassment claim on the employment equity ground, and it was limited to sexual harassment. Any matter now based on race, disability, which you could only take to the labor court, can now be heard at the CCMA as it currently, with the proposed amendments, which means that obviously there's more work for the CCMA to be done in that regard in terms of the disputes. And obviously what the impact is, racial harassment and multiple grounds of harassment can be arbitrated at the CCMA without one having to obviously simply just go to the labor court if they've got an issue around race, discrimination, disability, sexual orientation, gender, over and above that. So that's where it sort of ties in. Now, a key aspect of this, and I just want to touch on it, which is quite critical, is that with sexual harassment cases, unlike other cases, is that if someone was not happy with an outcome, whether the employer or the employee, they could appeal the decision. So what an appeal in layman's terms means that the matter could be heard again with all the witnesses coming in to the labor court. But the general scope of the labor court is that it generally deals with matters on review. So cases at the CCMA are heard with witnesses, everyone, cross-examination, and then over and above that, if someone's unhappy with the outcome, whether the employer or the employee, they can take it on review. So what review means is that everything that the labor court is going to deal with is the record. So only the documents and just the attorneys. You don't have to call in witnesses again to go through that. And I mean, you can imagine, obviously, in that regard, what that impact would be is that now that CCMA has more jurisdiction around this, or might have more jurisdiction around this dispute, then chances are there'll be more appeals, or maybe a consideration of appeals going forward as opposed to reviews. But obviously we're yet to see that. And I touch on this point whether obviously it would be feasible for employers, and in particular if witnesses were called in, there's 5 years that you wait for, people pass away, people leave, people are uncontactable if there are appeals. But that's just for consideration. What has also been included is that the Employment Equity Act, as opposed to a normal unfair dismissal, which is generally dealt with in terms of Section 186 of the Labor Relations Act, is as these two laws have different remedies. I think in section 193, if not 924 of the LRA, where in an unfair dismissal case, the amount that can be awarded is a maximum of 12 months. And I can tell you for free that rarely do commissioners or rulings ever reach 12 months. I think in my capacity, I've only awarded 12 months for two particular cases. One, an employer had sexually accosted his employee at a home. The other one, the employer had assaulted his employee with a firearm on the head, something to that effect. But generally, the amount that can be awarded, obviously based on the person's salary, was limited to 12 months. Or it could be reinstatement. So reinstatement, you go back as if nothing happened and you get back pay, whether your matter takes 3, 6 months, 3 years, whatever the case may be. And over about, or alternatively re-employment. So you start on a new job. Then now you've got obviously the Employment Equity Act harassment. So harassment, just when you hear the word harassment, think discrimination in the broader sense of the word, is that the commissioners generally tend to have wider scopes in terms of recommendations and financial implications that might come from there. So there's not necessarily a limited amount, so there are wider powers. So when an employee sometimes might have both a harassment arbitration and an unfair dismissal dispute, both claims now can be heard jointly at the CCMA. Now, I want to make this very practical for you, how this would work. Is that, for example, an employee is dismissed for incompetence or theft. Then when they go to CCMA or refer a dispute, it's an unfair dismissal, procedural, substantively unfair. They claim, oh, by the way, the reason why I was dismissed is because I'm Black, or because I was sexually harassed, or my manager was attracted to me. So you find yourself now as an employer, which is one of the things that you need to be mindful of in the back of your head, is that now you might be faced with multiple disputes which have potentially different remedies in the long run. One could be potentially quantifiable in terms of knowing what the maximum could be. The other one obviously might have different remedies, and in terms of obviously maybe being directed to obviously do trainings in that regard. And over and above that, the risk that you run, if you have an adverse finding against you for any sort of discrimination, is that obviously it might impact your ability to even do business with the government, because there's a certificate that is issued, the Employment Equity Compliance Certificate, that obviously if there's an adverse finding might also limit if your ability to do with the business with the government from obviously employment equity compliance perspective, and that might come for a period of time. So there's also that peripheral to be mindful of. So ideally, it eliminates parallel proceedings at the CCMA and the labor court simultaneously, because think about it, dismissals are dealt with at the CCMA. Then you've got another case, you have to go to labor court. The one could be dealt with expeditiously. The other one needs attorneys, costs, the delays in court proceedings in that regard, and obviously reconstruction, witnesses having to come in. So it was just intended to obviously provide a seamless process, which is where obviously the value comes in from a CCMA's perspective in terms of fast tracking disputes. And yeah, secondly, the consolidation of multiple statute disputes. The CCMA and the Bargaining Council gained expanded powers to determine claims under multiple employment laws simultaneously, combining unfair dismissal and discrimination cases in a single arbitration. Now, I want to go to the pros and cons, and that's very critical, and how that might impact the day-to-day runnings of practices, and in particular for employers. But is that you might have also multiple unsubstantiated claims. I use the example, someone is dismissed for theft and then they claim I was dismissed because I was Black. Someone is dismissed for assault, and I had a case like that. And then we got to the CCMA and the person claimed that, well, the reason there was also an issue around me being sexually harassed, and they had actually raised it in passing to one of the heads of the department, and obviously said that I don't want to pursue it. But later on, there was an adverse finding that the employer didn't do enough or in terms of its obligations around the sexual harassment, and obviously translating to any other discrimination. And then the employer was faced by finding fault in one. They were now faced with a R500,000 finding against them. So that's also the risk. The other thing is that even though the law doesn't say you must, the law doesn't say you must exhaust internal grievance processes, but ideally try to exhaust them, in particular for people who are so frustrated that they actually resign and claim that they were constructively dismissed because employment was intolerable. So it leads to potentially tedious internal grievance processes, in particular for employees facing dismissal. So sometimes, people have legitimate claims, sometimes people have illegitimate claims. So now you're facing a hearing for poor performance, ill health, and then you raise this discrimination ground, knowing that obviously if you get dismissed already, you've raised this issue, and I will bring it up as my sort of my sort of defense later on. And also, as I mentioned, it might be difficult to quantify the adverse awards because there are two statutes with two different remedies, and obviously a proliferation of outcomes could arise from that. So yeah, any questions? Sorry, I'm at the questions part. I thought I'd touch on them, but high level, basically. Does expanding CCMA jurisdiction, all forms of harassment, reduce barriers of justice for medical professionals who experience workplace harassment? Yes, that it does expand, does reduce barriers. No, it doesn't actually. It actually enhances them for the victims, but also opens up more doors in terms of multiple claims for the employer in this instance. So yes, it doesn't. It does open up the doors in terms of a less costly exercise as opposed to going to labor court, getting attorneys, legal practitioners in that regard. And as employers, practices and hospital groups adequately prepared for the increased arbitration exposure across all EEA harassment grounds? The reality is no. And there are multiple requirements when it comes to this, obviously educating employees, training them, and the risk that you run if people are not aware of their rights, other than the posters that you need to put on walls by law, is that you might have labor inspectors coming in to say you're not complying in that regard. And does the combined hearing provision, harassment dismissal, create efficient gains or procedural complications for respondent employers? Yes, as I mentioned the examples. And should SAMA advocate for specialized CCMA panels or extended timeframes for health sector disputes given clinical and professional complexity? Ideally, it would be nice to have a medical sort of related commission or bargaining council because of the nature of the field and the sensitivities and obviously the type of work, because it's obviously life-saving work. But in terms of extended timeframes, the reality is that as professionals, we are busy. So if we're not available today, chances are there'll be another emergency. So I wouldn't recommend it in that regard. And how should members update their internal disciplinary grievance process to reflect broader CCMA scope? As I said, there's already a requirement that generally as an employer, you must display the laws in that regard, but the reality is that also educating employees and updating your internal policies. Let me just stop sharing. Sorry, let me come back. Yeah. Any questions there? I'm just mindful of time.
The first question is from Pindile Nomakwe. It says, with regards to labor laws, which documents or posters should we display in our practice and how do we get a hold of them?
So generally, you need to have the basic, just a summarized version of the Basic Conditions of Employment Act, summarized version of the Employment Equity Act, and I'm not sure about the LRA actually, but generally most people would codify this in line with the LRA in terms of their internal disciplinary processes. I know there are multiple companies that sell these. I'm not sure whether you could approach the Department of Labor to assist with obviously a copy of it, but I know generally there are multiple HR consulting companies that sell these. And over and above that, these need to be displayed in places that are accessible to employees, like your kitchen in that. Over and above that, or the common areas, and you should be in compliance in that regard.
Okay. Thank you for the response. The next question, which will be our last, is from Dr. Vainan Hussain. It says, to minimize the risk to the employer of false claims, presented to the CCMA, would you advise utilizing a HR consultant to manage all employee incidents?
Yeah, ideally, you rather have guidance when you deal with labor matters. If you can afford it, have someone that's your go-to person or certain companies that you consult with in that regard. But what we can never do is we can never agree that the person cannot exercise their rights at the CCMA, whether real or imagined in that. But it does mitigate the risk in terms of litigation.
Okay, thank you. That was our last question.
Thank you. Thank you.
Can we have a round of applause for Advocate Moyake? I will go to the next speaker for our next topic. The topic is remuneration changes. And our speaker is Advocate Ramela, who's a member of the Bridge Group of Advocates and an expert in labor law, and has participated in aspects of the current bill and the Constitutional Court. Over to you, Advocate Ramela.
Sorry, I
You
didn't
can
realize I
unmute.
was muted.
Thank
There
you.
we go. Thank you, Dr. Koza. Right. So before we continue, I have not prepared slides for my presentation because the presentation brief did set out that you either can prepare some slides or not. So I've opted with not preparing slides. So that means our participants need to pay more attention to this topic. But yeah, I just wanted to get that out of the way. I will make sure that I'm audible and we don't have any issues. So the amendment bill has also proposed a change in remuneration, right? Firstly, severance pay. What is severance pay? Severance pay is the statutory payment made to employees who are retrenched due to operational requirements. So operational
Sorry, Advocate Romela, I just want to find out, do you have a presentation? Are you showing the presentation or not?
No, I'm not showing any presentation, Renee.
Sure, okay. Sorry for interrupting.
Slides voluntarily, so. Okay, so what is severance pay? Severance pay is statutory payment that is made to employees that are retrenched due to operational requirements. So the LRA, Labor Relations Act, sets out what operational requirements are. So maybe an individual, an employee is dismissed, or rather, sorry, retrenched because the company, the employer is no longer making a profit, or maybe the employer now has equipment that don't need labor, or maybe an employee's position now requires a qualification, and maybe the employee that is in that position at the time does not have that qualification. So that is enough for the employer to retrench the employee operational requirement. So how is then severance pay calculated? Currently, it is at 1 week's remuneration per completed year of service. The amendment bill proposes a change, an increase to 2 weeks. So instead of 1 week's remuneration per completed year of service, it will increase to 2 weeks remuneration per completed year of service. However, this will only apply prospectively. So it will not have a retrospective effect. Let me make an example. If an employee is employed for 15 years and the amendment bill is then implemented tomorrow, how will severance pay be calculated in the event that the employee is retrenched? So the 1 week's remuneration will be calculated for the 15 years that they were previously employed for. And then the 2 weeks remuneration will only apply prospectively. So if before retrenchment, the employees then continues to work for additional 5 years, then the 2 weeks remuneration will only be calculated based on the 5 years. So that's what it means when this remuneration calculation is based on being prospective and does not have a retrospective effect. So this proposed amendment from a legal policy perspective, sure, it probably will have a positive impact because it is going to improve statutory law, it is going to strengthen bargaining leverage in retrenchments, and it also signals greater protection for employees generally. But is this going to be adequate for highly specialized professionals in the medical space, medical professionals? Even though 2 weeks per year may appear significant in absolute terms, it might not have adequate or constitute an adequate compensation when assessed against the realities of the sector. What do I mean by this? In my opinion, medical practitioners will be limited when it comes to the increase of two years. Yes, it sounds like it is a positive impact, but still, is it going to adequately protect specialized professionals, medical professionals? In my opinion, maybe not, because there may be limitations specifically in the medical profession. For instance, it might not still account for specialization or scarcity of skills. And it also might still provide an incomplete protection due to the prospective application that it has. So in essence, the proposed change might not achieve substantive fairness for highly specialized, high investment professionals like medical professionals. So the second proposed change concerns individuals who are classified as high earners. So there is a threshold. My learned colleague has mentioned that there is a threshold that is set by the Minister of Employment and Labour in line with the PCEA. And if an individual is, or if an individual, an employee, their income per annum exceeds the threshold, reinstatement is no longer available as a remedy. So this is what the amendment bill proposes. If an employee exceeds, or an employee's income per annum exceeds the threshold set by the minister, then in a situation where there's an unfair dismissal, the only available remedy would be compensation, and reinstatement would then fall away. So the implications with this change, if it is implemented, is that firstly, this departs from the current Labor Relations Act's position, because reinstatement is the primary remedy in unfair dismissal disputes. Obviously, if there is, or rather the outcome in the unfair dismissal dispute is in favor of the employee, then currently it's either they will be reinstated or they will be compensated. But if this amendment is introduced, the reinstatement falls away and only compensation is going to be implemented. But in terms of the LRA, reinstatement is the primary remedy. And then compensation is the secondary remedy, and it is limited to 12 to 24 months remuneration. That means employers can then dismiss unfairly with no risks of being forced to take their employee back. So again, from a legal point of view, this departs from the Labor Relations Act, and this specific proposed amendment should be looked into some more. The second issue that may follow, or implication that may follow from this proposal, is that It creates a two-tier system of protection. The amendment, proposed amendment, explicitly differentiates based on income. So lower income employees have full protection, reinstatement or compensation. But high income employees have limited remedies. In this case, they will only be entitled, or rather, they will only have as an available remedy compensation. Now, obviously, this raises constitutional vulnerability because there will be a potential tension with Section 23 of the Constitution that sets out that everyone has the right to labor practices. Every employee has the right to fair labor practices. The other constitutional issue would be that there'll be a risk of unequal protection based on remuneration. The other issue that may follow from this proposal is that there will be an increased risk of opportunistic dismissals because liability will be capped. Now, this is in an unfair dismissal situation. So employees may calculate dismissal as a cost of doing business, and there might be a greater risk of strategic removals, particularly in high-level roles, because if the individual earns more than the threshold, then reinstatement will not be available. So this could be a tactic that employees may implement in their workplace. So in a nutshell, removal of the reinstatement remedy and an introduction of a proposed cap, which I will also discuss shortly, will significantly dilute the employment protection for high earning medical practitioners, which is not what I think we want, and I don't think that's what the law is intended to do. So the other proposed amendment under remuneration is that high earning individuals, so individuals who are earning above the threshold, will, because we've already spoken about they don't have reinstatement available, they'll only have compensation available as a remedy. But this compensation will have a cap. So there's a dual compensation cap. This is what's proposed by the amendment, that if you're a high earning individual that exceeds the threshold, then there should be a dual compensation cap because reinstatement is no longer available. You will only be compensated in the event that you get an outcome in your favor as an employee in an unfair dismissal dispute. You'll only be entitled to compensation, but at the same time, that compensation is capped. What do I mean by that? So in instances where an arbitrator commissioner finds in favor of the employee and the award, an arbitration award, would be compensation. So the compensation is capped to either 12 months of that specific employee's salary, or it will be based on the ministerial rand ceiling. The problem with this dual compensation cap is that the ministerial rand ceiling is not currently prescribed, and this may have some legal, also it may have some effects in terms of the rule of law, because it's going to create uncertainty for employees and employers. There also might be risks that are frequent and politically influenced. And this may also undermine predictability in the application of dismissal protection. The last thing that I'd like to address under the proposed amendment, specifically remuneration, is deferred payments and fines. Now, the National Minimum Wage Act applies, and the Act prohibits employers from paying employees less than the minimum wage. Currently, the minimum wage is calculated at 30 Rand and 23 cents per hour. So what is the amendment, the proposed amendment that the bill seeks to have implemented eventually? The bill proposes clarifying that deferred payments such as retirement fund contributions are excluded from the wage calculation when determining compliance with the national minimum wage. So this is intended to ensure that the minimum wage reflects actual take-home pay. So what are the exclusions of deferred payments from the national minimum wage, or rather in terms of the national minimum wage, and in order to be in compliance with the national minimum wage? The bill clarifies that a deferred or contingent payment such as profit sharing, performance bonuses, or incentive-based payments do not form part of the national minimum wage calculation. So these do not count towards the national minimum wage. What is the legal effect? Employers now must ensure that the base wage alone meets or exceeds the national minimum wage, and also variable or delayed payments are treated as separate, or they are treated as additional remuneration. Lastly, the amendment bill also proposes that there should be a change when it comes to fines. So if employers are paying their employees a wage that is below the national minimum wage, then there are penalties that can be applied. So the bill introduces significantly harsher fines. So if the employer is a first-time offender or there's a first offense, then there must be 2 times the amount of the underpayment. So if the employee has been underpaid, currently an employer will be directed to make a payment to the employee 2 times the amount of the underpayment if the employer, or if it is the employer's first offense. So this is what the bill is trying to introduce. But if the employer is repeating an offense, so the employer is not committing this offense for the first time, then the bill introduces an increase of 3 times the amount of the underpayment. So these amendments seek to represent strengthening of wage protection mechanisms, and an enhanced penalty will definitely create real deterrence against underpayment. So in essence, the bill seeks to propose that employers should have a harsher fine in situations where they are underpaying their employees, because there is a national minimum wage that has been set, and they should not pay their employees less than what is set. That concludes my presentation, and I am open to any questions. Thank you.
Thank you for the very insightful presentation. We can give applause for our advocate Ramela. We only have time for one question. We have a question from Pindile. It says, which is the most reasonable or acceptable reason for retrenchment?
So, as mentioned at the beginning of the presentation, operational requirements allow an employer to retrench employees, because we have situations where a company goes from making profit and being able to pay employees and be able to also tackle their operational expenses. But the same company can also start making a loss, or the company might introduce machines or equipment that don't need specifically a human to operate that machine. And in those instances, an employer can also retrench, because if they have equipment, I mean, there's the world is ever developing, and if there's new equipment, new machinery, new whatever that is introduced in the employment space that does not require humans to actually operate them, then obviously the employer will not keep any human capital. So the employer can also retrench in that case, and that retrenchment will be lawful, provided that they can prove it, and provided that they can show that this retrenchment is not unfair, or it is not unlawful, but it is based on this operational requirement. So to answer the question, I don't think there's a specific situation where an employer can retrench. It varies. There's different issues that different companies face, but if that reason for retrenchment is based on operational requirement, then most likely the retrenchment will be lawful and will not be opposed. I hope that answers the question.
Thank you so much for the very insightful presentation.
Thank you.
I believe the colleague will be answered. We'll go to our next speaker. It is James Velman. He will be taking us through collective bargaining, and he's from Velman Attorneys. He assists corporates and individuals to resolve legal challenges through innovative legal advice. Over to you, Mr. Velman.
Thank you, Dr. Koza. Just to confirm, everyone can, or at least someone can hear me?
Yes.
Thank you. All right. Good evening, colleagues, and specifically in this call, it seems to be medical and legal colleagues. So good evening to everyone. Thank you for the opportunity to address you today. The Labour Law Amendment Bill of 25 proposes several significant changes to the Labour Relations Act. While many of these amendments are sector-wide, they carry particular weight for the medical profession, especially in the private sector and for practitioners working as locums or contractors. I think you've already heard from the other colleagues exactly how these amendments would impact your sector as a medical sector. My aim this evening is to unpack certain key provisions related to collective bargaining, highlight their impacts on healthcare, and stimulate your discussion into the practical implications for doctors and SAMA. Now, do you obviously understand, first of all, what I'm talking about when I say collective bargaining? I will quickly provide you with a definition. Collective bargaining in South African labour law refers to the process of negotiation between one or more employers or employers' organizations. When you hear that word, think of unions or employers, and one or more registered trade unions. Now, trade unions in this sentence means trade unions that represents employees. Now, the collective bargaining process is undertaken with the objective of reaching agreement on matters of mutual interest particularly terms and conditions of employment, collective agreements, and workplace governance issues. And a quick example of this is colleagues in the public sector will know about all of the policies and regulations that are issued by the Bargaining Council for the public health sector. And those conditions are then incorporated into your conditions of employment when you are employed at the public hospitals that you work at. That's where your conditions are sourced from. So all of those conditions has come from a collective bargaining process that has taken place between employers and trade unions and ultimately ends up in your contract of employment. In the private sector, there is no bargaining council. So there is no formal structure where trade unions and employers organizations meet and decide on these bargaining or these collective agreements which contain employment conditions. So in the private sector, it boils down more to what we call a shop floor negotiation, which happens between a single individual and the employer itself, or there might be a trade union in the organization or in the hospital that represents a few or most of the employees and then negotiates on their behalf. And obviously those agreed terms and conditions becomes part of a contract of employment ultimately. So as you can see from this definition, although collective bargaining is definitely not in the limelight and discussed every day, it does form a underbelly, if you can call it that way, and sometimes the nasty underbelly of employment relations, where unions and employers duke it out to try and secure the best type of deal for their members and or for employers, obviously, for their bottom line, as they don't want to pay too much at the end of the day. Okay, so the understanding of collective bargaining is drawn primarily from the Labour Relations Act, and specifically Chapter 3, which regulates collective bargaining structures and mechanisms. And this is also where most of the amendments that I'm going to talk about is proposed by the amendment bill. So the first section I would like to refer you to is a section that deals with strike rights, or the right to strike. And it is section 65 of the Labour Relations Act. Currently, strikes are prohibited in the essential services sector, such as emergency medical care. The amendments broaden this definition to include administrative support and wider clinical functions in healthcare. So the effect of the amendments that are being proposed to section 65 is that a bigger category of medical staff will lose the right to strike when the disputes are, and their disputes, if they do have one, where they would have had a right to strike, now needs to be referred to compulsory arbitration instead of having a right to strike at the end of the day. Again, the best example of this will be in the public sector, where there are various unions with a lot of members that are able to organize and pull off a strike that can have a good effect for their members. In the private sector, obviously, employees are not as organized, and therefore, this might not have such a big impact on their day-to-day workings in that sector. The amendment raises a constitutional question under Section 23 of the Constitution, which guarantees the right to strike. The balance between uninterrupted healthcare and fair bargaining is delicate, and the amendment risks tipping it too far against labor rights. Now, as you would know already, as we sit here, most doctors are not allowed to strike because you form part of essential services, or in this case, essential emergency medical services. So you do not have the right to strike. What this amendment now seeks to do is to broaden that pool to your administrative staff and all of the people in the hospital that does have the right to strike at this point in time, and include them under that essential services umbrella, which will obviously limit more people's right to strike. Now, obviously, I believe there will most likely come a constitutional challenge if this amendment goes through in its current form. I do not believe that the unions will idly sit by and let this happen. It will most likely end up in the Constitutional Court, where they will have to decide whether this amendment will stand or fall away or be amended in another form. Right. I would like to quickly then move on to sections 70 to 72, section 74, and section 77 of the Labour Relations Act, which are all sections that are being proposed to be amended by the new bill. And in this regard, sections 70 to 72 expand, as they currently are, the amendments into these sections will try to expand its authority for the Essential Services Committee to designate essential services, but also place it under closer oversight by the Department of Employment and Labour. Independence is therefore reduced. Now, you've heard me regarding the right to strike mention the essential services and the emergency services which are not allowed to strike. Now, there's a committee which is called the Essential Services Committee, brought into life by the Labour Relations Act, who designates these essential services and makes a decision on who should be included into those definitions, and how their right to strike should be regulated, and if they are allowed to strike in certain circumstances, and so forth and so on. Now, what the amendments to section 70 up to 72 tries to do, it is now expanding the authority of this committee, which I believe is a good thing, because this committee has, in essence, experts sitting on it, advising on the decisions that needs to be made. But the problem that also seems to be creeping into these amendments is that this committee is now being pulled closer to the Department of Labour and its political oversight, which it tries to then throw over the Essential Services Committee. So where it was on its own authority, had its own decision-making powers, these sections now seem to try and bring a lot of that authority back under to the Department of Employment and Labour, and therefore the independence of this committee is in jeopardy if the current amendment goes through as it is. Section 74 entrenches arbitration as the default dispute resolution mechanism in essential services. As you heard me earlier say as well, the right to strike to more people are being, or the right to strike of more people is being taken away by the previous amendment that I discussed. And this section 74 is the arbitration route that needs to be followed. And therefore, this section is amended to state that this is the default dispute resolution route in a situation where, in essence, certain people had a right to go and strike. Now you have to go and arbitrate, which in my view is not necessarily a bad thing. A lot of strikes do not result in the kind of results that unions or the employees envisage when they go on these strikes. But an arbitration before a single decision-making authority is, I believe, a better opportunity to maybe secure what you as an employee or as a trade union might be looking for. And even an employer in that sense. Employers can provide their case and their facts before an arbitrator, and the arbitrator's decision is binding and final. The amendments to section 77 envisage to strengthen enforcement powers, allowing faster compliance, but imposing harsher penalties for unlawful strikes. We can have a long discussion about what kind of penalties needs to be imposed on people who strike unlawfully, but you know, I only have so much time to present this evening. But in effect, the amendments that are being proposed to 77 will have those results that flow from there. What does it mean for doctors? It basically means that disputes in hospitals or clinics classified as essential services will bypass industrial action, which is strike action, and arbitration will be the binding and swiftest way to bring your dispute to resolve at the end of the day. All right. Then lastly, I would like to move on to the proposed amendments to section 32 of the Labour Relations Act. Section 32 talks about bargaining councils. Again, the colleagues in the private sector, the public sector will be more knowledgeable about bargaining councils as they do belong to one. But the private sector colleagues would not necessarily understand this concept of a bargaining council, because one doesn't exist for the private sector. So Section 32, the amendments tries to tighten requirements for extending bargaining council agreements to non-parties. Again, this does not really affect private sector colleagues, as they there is no bargaining council, so there's no need to worry about this until one is brought into existence. And these amendments also try to bring in more regulation regarding how bargaining councils will be set up if they need to be done so for the private sector. It introduces mandatory consultation and expansion coverage for atypical workers, including part-time and contract staff. And I know this stuff is very boring, but it is what it is. This is what a bargaining council does. While the public sector has the public health, I'm going to mess this up. It's the PHSDSBC. That's the acronym for the bargaining council. The private medical industry currently lacks a bargaining council. This means private doctors and locums are not covered by sector-wide agreements. I've already indicated this in the previous amendments that are being brought through. So yeah, bargaining councils that you need to take note of is that, if you want to establish one now for the private sector, it's going to be a bit more difficult to do so, as there's more regulations that you need to take into account in that regard. All right, so just want to check through this note quickly that I covered that issue for you properly. Yeah, I've discussed that there is only a bargaining council for the public sector. And this then brings us to questions which you need to consider maybe for discussion purposes, just to keep in mind. I'm sure it's part of your briefing pack as well, but just to lend my thoughts to these questions quickly. So first question: if locums gain collective bargaining rights as dependent contractors, you've heard Letitia talking about that, should SAMA establish or support a bargaining structure for them? And what would this look like? I'm not going to talk about what this looks like. That's up to you guys. You need to decide what you want to do there. But I would think that the answer to the first question should be yes. If locums are now going to be seen as dependent contractors, and they do have all of these rights that come with that definition, as you've heard from Letitia, then surely it would be a good idea to get into the shop or get into the ground floor with them and maybe start organizing them in a way that benefits SAMA or the locums and SAMA, for future purposes going forward. So that's my thought there. Next question: does the new ability to conduct partial strikes in essential services compromise patient safety in hospitals and emergency departments? What safeguards are adequate? I believe the current structure that we have, where essential services and specifically medical staff and so on are excluded from strikes, is the correct way to go about this situation. I believe that the oath that doctors took must supersede any dispute that they do have with the employers in the current situation, and that a person's life is obviously much more important than any dispute or strike that might be currently ongoing or not. What I do believe the amendments try to do is to create a mechanism that better channels the medical profession or the medical services or the medical fraternity to arbitration to resolve their disputes. It's unfortunate that it now includes a bigger pool of people that might lose their right to strike. But if that is the price that we have to pay to keep the current structure in place, then I believe that is the right way to go. Yeah, that's my view on it. Obviously, you're welcome to disagree with me on that point. The next two questions I do not believe is really relevant to a discussion. As I said, there are no bargaining councils in the private sector, and the only bargaining council is in the public sector, and that bargaining council is what it is. I don't think SAMA is going to change anything about that council in this current discussion or these amendments that are being pushed through or proposed to the Labour amendment or to the Labour bills. And then lastly, should SAMA seek a health sector carve out in the collective bargaining provisions or engage proactively with the new framework? I believe there is so much room in the medical unit or the medical collective unit for a properly built union, and specifically a SAMA, an organization that can organize its members and negotiate, hopefully in the private sector specifically. In the health sector, we already have the bargaining council and the unions there, but there's obviously space for as many unions as possible in that space. But specifically in the private sector, there is really no union for doctors that really takes up the challenge that is being presented in the private sector for doctors, specifically employees. And I know I'm talking about doctors. I know that certain doctors are also employers and that you don't necessarily want more unions to be in your workplaces. But ultimately, if we look at the demographic, there's certainly more employees working than there are employers in the medical sector. And it would be good to try and organize these people as best as possible. And then, yes, SAMA is obviously a great organization that can step into that framework and get those people organized. So in closing, and I am aware of the time, so I'll keep it brief. In summary, the bill expands, the amendments expands essential services designations. It narrows strike rights for a certain group. It strengthens arbitration and enforcements, and it introduces dependent contractors to the pool of collective bargaining. That's if all of the amendments go through. So for the medical profession, the implications are profound. There is reduced industrial leverage. Like I said, less people or more people have now do not have the right to strike. So there is less leverage for medical professionals in the industrial or in using strike action to their advantage. There are potential constitutional challenges, as I said, that is definitely going to come across the table of the Constitutional Court in regard to these amendments that are being proposed. And I specifically highlighted the strike issue. I do not think the unions will sit idly by on that issue. And then lastly, there's definitely new opportunities for collective bargaining in the private sector, as I've highlighted to you earlier on. So as members of SAMA, it is vital to engage with these reforms proactively, both to safeguard constitutional rights and to ensure that doctors, whether employed, contracted, or locum, are treated fairly under the evolving labor law framework. Thank you for the time that you gave me tonight to address you on these issues. And then, yes, if there's any questions, I'll be more than happy to answer those.
And Dr. Koza, I think you're still muted.
Oh, thank you. Thank you for the insightful presentation. I just want to ask colleagues to take their time to complete the survey, which we posted on the chat. We've got one question on the Q&A. So it's from Dr. Yende. It's basically asking whether if there's a strike in your hospital and you are prevented from entering the facility or exiting, are you regarded as being part of that strike or not, even if you were not intending to participate?
Yeah, well, if the facts clearly show that you've tried to enter the facility and you were prevented to do so, I don't think any reasonable decision maker in a process will find that you are partaking in a strike. So definitely not. If you are prevented by other people from doing your work, you do not automatically get associated with the strike. If that maybe answers the question, yes.
Thank you. I'm just wondering what facts would be enough to prove that you tried to enter, because you are not at work. Everybody else is not at work. So,
yeah, well, maybe to answer that, in my view, the question would propose facts that there's an observation being made that the person is trying to enter the hospital to do work, or maybe get into the hospital parking. I mean, there's examples of case law where strikers bar entryways and things like that, and people are prevented from entering the building specifically. So if there's evidence to that effect, then clearly the person was there to deliver their services and they were prevented by the strikers to do so. And again, in those situations, I don't think you'll automatically be assumed to be part of the strike if you do that. So, no, but if you just stay away from the hospital, then there is a question that could be asked specifically if you were scheduled to work and you did not maybe report that there was a problem to get to work, then there might be a problem in a situation like that, yes.
Okay, thank you. That was our only question. Applause to Mr. Wellman, and thank you again to all the colleagues who took their time to attend this session, and all the speakers. You could see we had very learned speakers. Unfortunately, the time was limited, but we'd like everyone to please take their time to complete our survey. So your responses to the survey, they will help us formulate our input for the current labor law amendments. So we kindly request that you take your time so that your inputs are heard. Thanks to everyone for taking their time. It was quite an insightful session. And good night and goodbye. Don't forget the survey.
Thank you.
Bye-bye.